I am your host, Simon, and today I'm joined by very distinguished guests with immense experience in the real estate sector. We'll try delve into the topic of buy off-plan properties as they provide this information that will be crucial for your understanding. Today, I'm joined by our guests from Byrant, Kenya and CM Property Digest. So we try to have a robust discussion. I'll let them introduce themselves. Karibuni sana.
Thank you. Thank you. Thank you, Simon. My name is Wendy Gunga. I am the head of business development at Byron, Kenya. I have been in the real estate sector for about a decade now, specializing in both sales and development, and excited to be here. Yes. Mm.
Thank you. Thanks, Simon. So my name is Joan Miner, and I'm the legal researcher and editor for CM Property Digest. And I'm happy to be here today and excited. Let's see whether we can delve deeper into the off-plan properties. It's really trending.
Yeah.
So yeah.
Karibuni sana.
Yeah.
So probably to give our audience some bit of background on what we're discussing today. Definitely, what are off-plan properties?
So off-land properties are basically developments that are bought before the completion of the structure. And how it differs is that most constructions are usually done, and then now the purchasing is done afterwards. So once a developer decides to embark on a project and now do the construction as they've already gotten payments, that's what we call an off-plan property. Yes, that's the big difference between that and the usual developments that happen. It's sort of a new thing into the market. It's a new thing in the market, and we are currently seeing the developments as they go. And I guess even statute is trying to also keep up with that and regulate that.
For sure. Maybe just to also capture on this, what are some of the most important things one should know when dealing with an off-plan property?
I think the historical overview of off-plan, it's really blown up in the last 5 years or 5-10 years in terms of real estate, because prior to that we would buy properties that are complete, that have people ready to move into. So this has been a game changer and allowing more entrants into the market, because this is the highest value of property we've seen in the market. It's the highest it's ever been. So this is an easier way for new entrants into the market to find a feasible, affordable way to purchase property that they know that they can sell off later on. So I would say it's really blown up in the last 5-10 years. So it's really important to know that it's a new concept. It is still emerging, and it's important to you for you as a buyer to actually do due diligence into what this is as a concept and in the particular development you're interested in.
Okay.
So I think maybe I can also add on that
Sure.
because as an advocate and in the legal sector, you must ensure due diligence is done thoroughly. And the first thing I can tell somebody is obviously to have legal advice or a representative there, because they're the number one. They're the people who can spot red flags, whether it comes to documentation or even on the land. So the second thing is that you have to ensure that you have a search, which means visiting the lands Ministry of Lands, so that you can check and see whether the title deed of the property is well registered, and whether there are any encumbrances that are on the land, so that your interest is not defeated
Okay.
by any other overriding interests. And then thirdly, I can talk about also permits, because you need to ensure that the building that is being, the development rather, has the proper permits. There's usually building permits, all sorts of permits, and you must make sure that once you now obtain the title, or rather when you want to engage within the transaction, the building is viable for the permits that are usually released by even local authorities. Many times, usually local authorities are involved when it comes to permits. Yeah. So that's the bit about the due diligence that needs to happen. Yeah.
And I think just to add on to that, Offplan have a really bad rep in the market right now
Oh, really?
because of the trust factor in terms of you're promised one thing very different down the line. Developers not following through in terms of timelines or not actually giving the buyers what they promised at the very beginning.
Yes.
So that's a big hindrance to that investment. And that's the biggest challenge we're facing, especially in terms of sales,
Okay.
because the trust factor is just not there. So, going back to what Joanna said, the due diligence, I think, is the most important step before taking that route of off-plan development.
Nice.
Yeah, so just check the reputation, check the history, see whether their transactions are usually clean. And maybe you can have an issue when it comes to maybe a new developer.
Yeah.
That particular issue can come up because now you can't check their history. They're new into the market. So maybe what I would advise is for somebody to deal with people who have been in an industry, and you can see players in the industry like Wendy and Byron Kenya will be able to guide you on that. Yeah.
Yeah.
So essentially, we now have an overview of what an off-plan property is, some of the aspects you need to do that is concerning due diligence. But again, you're getting into a transaction, whether you're a developer or the seller, whether you're an agent, so you're working in between the developer and the buyer themselves. Essentially, this means there has to be some written agreements in between. That's the contract itself. So essentially, how would you go about the review of an off-plan property purchase or sale? I understand it's a contractual aspect you need to.
Maybe I can start from the beginning in terms of when you approach an agent.
Sure.
They should have a contract with the developer in terms of obligations for both the agent who is bringing you to the ground and the developer, what they're promising in regards to service to your buyers, to the agent's buyers. So dealing with a credible registered agent, they should be registered by the estate agent registration board. Really makes a difference because they have the expertise to be able to do due diligence even upon themselves before they start selling. So I think that would be the first step in terms of contracts, ensuring that the person you're dealing with in terms of the property actually has a contract with the developer in terms of obligations.
Okay.
Yeah.
Yeah, and when I speak about contracts, I will always advocate for a lawyer to be present throughout the transaction from the beginning. You have to have somebody who is able to check and see and understand those clauses to ensure that your needs are met and you're not being duped. So legal representatives are always going to be able to, a real estate lawyer specifically needs to be within. And when it comes to the contract, I think I would advise that certain clauses, such as the penalty clauses, when the developer is not able to finish the rather perform their duties, they're not able to complete the development, needs to be there. You need to have conditions for any refund in case of the developer does not complete the project. And even your finances, how you're going to ensure that the money is being released in stages, that is also included in the contract.
Yes.
So the financial plan kind of has to be reflected within the contract. And then I think also the standard of the building needs to be addressed within the contract, so that you are able to get what you have bargained for rather than something else. And then when there's legal disputes, you can have a written reference of what you expected. Yeah.
So essentially, whether you're coming into a contract as a pro developer or under a pro buyer agreement, you need to understand what are some of the contractual clauses that protect you. So if I'm coming in as a seller, how will I ensure that payment is made to my end? Yeah. When I'm coming in as a buyer, am I protected in that if the developer rather doesn't complete the project within a given time frame, what recourse do I have? What are some of the conditions? What do they warrant to me? Do they warrant that they're actual developers, that this is actually what they do, that in case of a failure from their end, I should be able to argue my case that yes, they put it to me, they're developers. Much as they're new in the market, they're experienced what really should go on. in terms of the recourse I should have, right?
Mm.
So technically, as a contract, you'll have yourself covered, whether you're the developer, the buyer, even the agent, right?
Yeah. I think just to add on to that comment, maybe you can outline what type of contracts. I mean, contract is a general term.
True.
But we've seen offer letters, we've seen sale agreements. So, what contracts should they be very keen on when purchasing an off-plan development?
Most of the agreements will happen at the sale agreement stage. So that's the main contract that you should look at, and that's where all these discussions about how financing will be done is usually captured. So you find you have to stick to, for example, the buyer has to stick to the price that has been set within the sale agreement. Whether there's any changes in the market, they'll stick to that. When it comes to conditions, they're also still captured within that sale agreement.
Yes.
And you default on that, the sale agreement is still part of the reference, even when there's a legal dispute later. When it comes to even penalties, still within the sale agreement. So to answer your question, it's the sale agreement that needs to be focused on and polished when doing this transaction. The offer letter kind of just gives you an overview of what is going to come within the sale agreement.
Yeah.
So usually you find the lawyers will, after debating, they will get the offer letter, then debate and see what it is that both of them will agree on, and then it's put in the sale agreement. So the sale agreement must be clear, and that's the what do you call it? The reference point, basically. It's the one that holds the water.
Okay. So now that the contract is in place, parties know what they're dealing in, it comes to the idea of finances. So financial obligations when you're dealing with the purchase of an off-plan property, how do you ensure that um, some sort of financial due diligence is done in terms of trying to understand how your finances are protected when you're actually buying this particular property? You as the buyer, it's something that hasn't taken off the ground. You're coming in to be part of the project. How do you ensure your finances are protected?
So maybe I can start off with how financing works from a buyer perspective.
Perfect.
So essentially, when you're purchasing a property on an off-plan development, most of the time you get an offer letter stipulating a deposit that is required before proceeding to the sale agreement stage. So this would be either 10%, 20%, 30%. Usually, the higher the deposit, the cheaper the price is on the unit.
Yes.
And thereafter, they are proceeded to the sale agreement stage, where now they now mediate with the lawyers based on the requirements for both the buyer and the seller, and then they now agree on the installments, whether monthly, quarterly, yearly, in terms of how to complete that payment. So before someone pays a deposit, there's usually that trust factor. So maybe, going back to Simon's question, for financial due diligence on developers, that's usually the biggest question mark. Are we sure that they're gonna complete this development? Do they have the finance to do that?
So when it comes to the developer side, because financial records are always confidential, you can't really guarantee that. Maybe you can check and try and see whether the loans that they have are with a bank that is, reputable or stuff like that. But you can't really rely on it entirely. So what you can do on your part is control how the payments are usually released. And you can do that using an escrow account. An escrow account usually exists so that you can keep releasing the money. Maybe you can check the milestones of the development. Once a certain particular level is done, then you pay this amount. Once another level is done, then you pay this amount.
Yeah.
So what I would recommend is that you don't pay a full amount at the beginning, because as we're saying, this is something that needs to be constructed and finished.
Yeah.
And so you need to pay in certain maybe installments. As she's saying, you do the deposit, then you do some certain installments later. And then there's you can also secure yourself maybe with an insurance bond.
Okay.
Usually insurance bonds exist so that you can be insurance bonds are they're designated specifically to protect from financial risks that exist within the industry.
Yeah.
So what happens is that if the developer does not complete the project, then the insurer will step in and make sure that you the money that you have given off has been replaced rather. So they cover you on that. So basically you can also check even the bond, what financial policy, what insurance policy are you getting, ensure that that is also covering you. And then there's bank guarantees where the developer, now on the developer side, they can take a guarantee so that they ensure that in case of anything, because calamities even do happen,
Yes.
and the guarantee is not able to the developer is not able to finish the project, not by their own defaults.
Yes.
And so now the purchaser is covered by the bank for the financial for the finances that they have incurred,
Yes.
basically. So there's different plans that are there. There's for the purchaser, you can do your private insurance policy. Some developers actually would even offer an insurance policy or a bond as they try to have an agreement with you. So there's many options, but basically you must govern how your finances are released. Do not do it all at once unless you're quite sure about this project and that it's going to be finished. That goes back, of course, to the reputation and how trustable the developer is.
Yeah.
Yeah.
Maybe I can ask for a buyer perspective. What is an escrow account? Who sets it up? And yeah, how do we get there?
Yeah, I think maybe Simon can
Simon, you
take
can
that
answer
one.
that.
Sure. So definitely, when it comes to money, it's
Yeah.
always, it has to do with significant apportionment of trust. So when I'm taking my money towards a development, towards a project, I need to be sure that my money is protected. So essentially, to also show the other party that I'm serious when it comes to, I want to purchase this particular property, I'll provide the finances. So to ensure my money is protected and to also give a guarantee on the developer's side, we place this money in an escrow account. Essentially, it's not like any other account. Once you get to the bank or your financial institution and mention an escrow account, it's technically a security account whereby you deposit these funds. They're not supposed to incur interest. They're only there being held by the bank as a third party, such that upon instructions from the one who deposited the money, this is the purchaser, the money can be released according to the instructions. So if it's half of the money, if it's a certain amount, it's kept, I would say, in safe holding by the company, by the bank, and being released as per the instructions
To the lawyer
to
or to the bank
to the developer.
or to the developer.
Yes.
Okay.
So the money is deposited there either by the buyer themselves or the advocate to
The buyer.
Yes.
So it's essentially then it's different from an advocate's account because
Mhm.
that's usually the dealing that happens with an advocate's account, but an escrow account is different.
Mhm.
That one is solely the purchaser is in the purchaser's control
Yes.
rather than the
Mm.
advocate.
Yes.
So that's where the security comes in.
So what's the need of having an escrow account in comparison to me just keeping it in my personal bank account? Because is there security that comes with that, or is it intended for one purpose only to use for this particular purchase of property? Maybe.
Essentially, you would say you could keep it in your account, but then we also want to confer some confidence to the developer that yes, I do actually have the money. So it's essentially a way of keeping the project running. Because remember, most of these companies that do off-plan try to advertise. You see on billboards, I'm pretty sure they'll advertise that 50% sold. So if it's 50% sold, and to those individual persons making the 50%, they'll need to be sure that if I'm coming as the next purchaser, the 50% done, is it something I can already see? That's why you need finances already deposited and secured to give the developer confidence that
He will follow through with your sale.
yes,
Yeah.
and the project is already off the ground. so that you can also go see, yes, there's 50%, it's 50% sold. I can see from a site visit that it's actually 50% done in a way.
Yeah.
There's development going on.
Yeah.
Yeah.
It's moving. Interesting.
So, come to think of it, in terms of construction has already gone on, it's like 50% through. How would you be able to tell as a purchaser? How would you be able to tell as an interested person or even as an agent, yeah, that something is going on the ground?
I think that's our biggest challenge. You'll see 50% sold, but it's actually 10%.
Exactly.
The rest are on offer.
Yeah.
Or a lot of defaulters down the road. Of course, this is a 3-4 year. I think with the new developments, especially the Chinese-based developers, you'll see them completing a development in 3 years. So in those 3 years, anything can happen with a buyer. Midway, they've maybe paid half the installment, and then something happens, they're not able to follow through, so the unit comes back into the market. So I think the biggest tell, I think, when you get to the ground is actually completed transactions, people who've paid full price, not installments, because anything can happen as you go.
Yeah.
So I say not to trust the 50% at the go, because it could be properties on offer, not necessarily have been purchased. So it's very critical to find out how many have actually been purchased end to end completion in terms of the payment and the sale agreement. A legally binding agreement has been signed by both the developer and the buyer, and the payments have already started coming in. So that's the best tell in terms of what has actually been offloaded in the development. Usually you'll find, when if it's off plan, around 30-40% is sold in the first 2 years, and then the rest on the final year.
Yeah.
So that's the best tell I can say as an agent or a buyer when you're walking in. Don't just trust everything that has been booked. It's more of which properties or how many units have actually been purchased with a legally binding agreement, and payments have been made on the same. That's the best way you can tell.
And how can you be able to confirm this? Wouldn't a site visit be, important to at least go see for yourself?
Yes, definitely site visits, and not just to that development, to also previous developments that have been done by that developer.
Sure.
A lot of the time they have a portfolio. You can also talk to buyers who have actually bought in their properties in the past. What was their experience? Did they have any issues in terms of legal? Because of course the developer comes with their lawyers. So that gives you a really clean overview, and you'll be able to tell very easily if there's a problem. Especially when visiting, you can see the level of construction, what the quality is, what will happen down the line. You're visiting properties that are probably 4 or 5 years old, so you're able to tell in terms of, is there any cracks on the wall? How is security? Is there any water issues? So you're able to really, really inform yourself as a buyer, because, like I've learned legally, it's not upon the seller to tell you the issues. So it's upon the buyer to do the due diligence of that. So it's very critical to visit previously constructed properties, and then go at a very critical hour, like 4 5 p.m., when there's rush hour. You're able to see it at its worst. Not to go in the morning when it's lovely and there's no cars on the street. So go at, it's called golden hour. You go check it out when it's really, when buses are there passing, so you can see what is it actually going to be like when there's life in the property.
Sure.
Yeah.
Yeah.
Interesting. So you've mentioned something very important. All these transactions, from you getting into a transaction as a developer with a potential buyer, uh, the understanding of how your finances will be protected, how you as a developer will get these finances, how to handle this particular escrow account. There has to be some form of legal framework to do with off-plan properties. What are some of the aspects to do with the legal framework itself? What do you look to? Are there policies or there guidelines? What is the law essentially?
Generally look at this.
So when it comes to the law of the land, of course, number one is the Constitution.
Sure.
And then we have the Land Act and the Land Registration Act, which usually gives how it usually guides how the transaction should go, what should be included in the agreements. And for that, it's usually the normal terms that are included there, honestly. So it's imperative for you to look at the local laws. Obviously, with there's different local laws because we have different local authorities and everything. So the counties have their different regulations, and the permits also come based on the type of development. So that is that is important, really. And maybe consumer protection laws can also come in.
True.
The buyer needs to be aware of the consumer protection laws that may offer recourse in the event that the developer does makes a default, rather, when they don't finish the development.
Sure.
Yeah.
Maybe just to bring it back on something also quite important, the financial stability of a developer. Already this developer is promising that you deposit your money with us or you pay within a certain period of time, we'll be able to finish the project within a given time frame. All this is dependent with money. How are you able to tell or confirm the financial stability of this particular developer?
I think from an agent perspective, it's very tough. I think it's clear that financial records are very confidential, as mentioned by Joanne previously. So for us, we can only due diligence based on their history. Have they been able to deliver, as well as knowing who a self-financed developer is and one who is using a charge to complete that property, or has financed it through maybe a local bank, etc. Because there are developers who have enough money to build on their own and then sell. So those are the ones I think we lean towards as agencies. It's basically less risk, but at the end of the day, property is very expensive in Kenya and it's hard to develop sometimes. So you need to look at finance options, which I'm guessing Joanne will also guide in terms of especially charged properties. Yeah.
So when it comes to financing, as I think we had mentioned about bank guarantees, so obviously when defaults happen, a guarantee steps in. So maybe that's one option that can be taken by the developer in case the financing does not measure up. And for the purchaser, we had said the insurance bonds, and maybe now financing also is very it can be very unstable, honestly. So those I can say are the two options that I can give for as when you have a plan, when you don't have a plan B.
Yeah.
And because you can't be able to completely say that you're going to follow through with this project if finances are truly not there. I guess you can say, like Wendy, I mean, we can follow Wendy and say that you're going to follow through with this project if finances are truly not there. I guess you can say, like Wendy, I mean, we can follow Wendy and say that you don't have access to financial statements of the developer. They're usually private, and so now you go with the history, see whether they're able to conduct their business and finish and follow through. And that's about as much finance due diligence you can do. It's very little. It's
Maybe
not
I
in your
tell.
control as a purchaser, really.
Yeah.
Yeah. So that
So
one,
history is the one. I think
it's
one of the
history.
biggest tells is when it keeps on stalling. You keep
Yeah.
on going to site, there's no one there, or
Yeah.
the crane has been taken. That's a red flag.
So essentially, still on finances, I think there's also the aspect of a mortgage. Yeah? How do you get, or how do you go about the issue to do mortgage and off-plan properties?
Okay, so when it comes to a mortgage,
Yeah.
there is usually a duty of the developer to finish payment. Do not default on the payment plan that you've been given by your chargee, because now that also affects the rights of the purchaser.
Yeah.
And I think as we had said earlier, there's usually a hierarchy of interest and overriding interest that happens. because a financier comes first when the loan has not been repaid. So what I can say is that the developer needs to ensure that financial obligation is met and that the chargee gets their money so that they're able to now do their dealings with the purchaser after the loan has been repaid.
Okay.
So they should ensure to keep up with their contract obligations, not pay too late, and then you have issues of now the chargee has come now to sell the property because there's this amount that is needed by the chargee, and it's looking like the developer doesn't want to pay. So just stick to your contractual obligations as a developer. That's what I would say about the financing. Do not clash with the financier.
Yes.
Communicate if there's any foreseeable default, so that your chargee also does not abandon you and begin to sell the property.
True.
Yeah. So collaboration with your chargee, ensure that you're responsible with your contract obligations. That's what I would recommend for that particular question.
Maybe a question from a buyer perspective.
Yeah.
In terms of paying that charge, is that information I can require from the developer? Are you paying your dues on time?
Yeah, so now another thing, it's a confidential
Also
thing.
confidential.
Yeah, you can find now you have to just look for the signs as you're saying. Maybe there's a crane that's been taken. It's looking like some people are in court. You're seeing the
Yeah.
sign. Maybe the chargee has already started advertising the sale of the property. That's how you can tell that there was a default. But when it comes to financial statements, it's very hard to get it.
To tell,
You
yeah.
can't really tell. You can try and ask, but honestly, it's not within your reach sometimes. So yeah, you just have to hope and pray that okay, not hope and pray, because when you're having a particular transaction that you want, you have to ensure that the consent has been given by the chargee.
Yes.
Because consent will not be given if the developer is defaulting. That's how you know that they're defaulting, and the bank will be like, no, we're not going to sell this. This land is not up for sale to any purchaser because there's still some obligations that need to be met. So you can do your own due diligence and get the written consent of the chargee, and that's usually stipulated under section 59 of the Land Registration Act, and I think section 59 of the Land Registration Act, and section 87 of the Land Act. You must get written consent from the chargee so that when you have your dealings, you have clean title as a purchaser. And I think maybe I can give a small there was a case that happened that was of that nature. You have a financier, a chargee, who has a developer who has defaulted. You, as the purchaser, you have also been included within this transaction. You've already bought this property.
Yes.
So in the case of it's called PJ Dave Flowers Limited versus Limuru Hills Limited, the purchaser went to court. They went to the Court of Appeal, trying to challenge the bank's interest versus their own. And at the time of the case, the bank had already begun to sell the property. And the property actually was sold. They had begun, and then it was sold it was auctioned off. And so when it comes to a developer defaulting and the chargee steps in under Section 90 of the Land Act, then there's nothing a purchaser can do. You need to protect yourself and ensure that the obligations are met and the chargee has given their consent.
Okay.
You must ensure that the consent is given, and consent obviously will never be given when there's a default.
And can you add this into the sale agreement? Like what happens in that situation when there's a default from the seller, the developer? As a purchaser, can I have that as one of the clauses in the sale agreement that basically shows what to do, what will happen in the case that the developer does not pay what is due to the bank?
There's you can bank on the penalties for when no, I don't think when there's already a financial agreement in place, that is the agreement that holds water. That is the one that's going to be referenced first.
Oh wow.
Then yours comes later, because you see the hierarchy of interests.
Yeah.
The bank's interest comes first, and then now yours. So how you can mitigate that is to get the consent from the bank, and then now the dealing of the property can be done under a partial discharge rather. So you will never find a situation where you will not find a situation where a bank, you're talking about the agreement of the bank
Yeah,
and the developer, because
the
you're now a
agreement.
third party.
Yeah.
Automatically, as a purchaser, you're a third party.
Okay.
So the bank has their own arrangement with the developer. You cannot step in and begin to,
Refer
demand
to
from
that.
it.
Yeah.
Yeah.
Okay.
I think based on what Wendy is asking, also from a buyer's perspective, when I'm just about to sign the sale purchase agreement, in the warranties clause, am I informed that in case of a default by the developer to
The bank, yeah.
provide or rather issue play with my property, what recourse do I have? Does the warranty clause mention that there is, or rather, the warranty clause is there to confirm that indeed we are a developer, indeed we are conducting this particular development, indeed based on our financial strength, our undertaking towards this particular transaction will be able to deliver. So definitely the warranties clause gives you an assurance.
Yeah.
But then in case that assurance is breached, what are the penalties? How will I be able to get back my money?
And I think this is the biggest question agents get. How do I get back my money in case something happens?
Yeah.
I think it was just back to that particular point of bank guarantees and everything. Those are the ones who you can rely on once a default happens. And yes, there should be that penalty clause. And that is only with you and the developer. The financier is not included. It is not included. The bank is not included. You get as a chargee, not as a bank guarantee. So you can vary what happens based on that sale agreement, what you have decided there. So truly, yes, there is that recourse, but you cannot now go and start searching for the financier. If they've already sold your property, that is a bit too bad. You have to now just start another legal dispute of another nature. Yeah.
Understood. So essentially, to avoid all these, challenges that come with dealing with property, because especially in Kenya, buying land, buying property is a very emotive issue. How do you ensure, whether you're a buyer, whether you're a developer, your intended clientele is confident with what you're doing, that me, myself, as a buyer, I'm able to follow through? How do I ensure that this is possible? How do I ensure, how do I effectively close on the purchase of this particular off-plan property? Is there a way I can communicate? How do I tell that they'll be able to live up to the words on the agreement itself?
I think from an agent perspective, it's more of ensuring, like you said, due diligence, very key, ensuring you have the right contract in place, historical analysis of what the developer has done in the market already, talking to the stakeholders within the ecosystem of the sales, so the buyers, even the agents who are on the ground, they know about these properties, they know about these developers. And I think consistent checking and follow through in terms of visiting the property, not the first time you're buying only. Yeah, every quarter or before every milestone, taking time to actually see how far have they gone, what is happening with my actual unit. Sometimes they've not reached the height that allows you to visit your unit. When it does happen, definitely go up. People are afraid of visiting the actual construction, but make the time to do it, because if you're not in their face, if you're not there all the time, or if you're not taking the time to actually check on your investment, then anything could go wrong, and then you're finding out way later than you should. So I think doing the work, I mean, every investment comes with work. So I think actually going to the ground and making sure you understand what is happening is very key. Also going as far as checking who are the contractors, who are the architects, who are the approvals still in place for this particular point of development, let's say at the completion in terms of occupancy, is it occupancy certificate?
Mm.
Ensuring that is already being done, asking questions about the sectional titles. I mean, that's a new some new legislation that has come into the market since apartments started really developing. So that's what I would advise, and then working with a registered agent who's able to guide you on the legalities, because that's something that we are trained on in the estate agent board. So not only, I'm sure lawyers are there, but just having someone to talk to on the ground is very key. And who's able to tell the red flags even before you are, because they would sell something they don't believe in. Yeah.
And I think maybe just to add a small one on that, because I think she captured it so well, is maybe you can have a documentation in terms of progress reports, ensuring that there's photographs so that you can now immortalize all this on paper and have it with you as an official document. This is where this milestone has reached. Now that we've reached here, that's what I can maybe recommend. A progress report is important.
Sure.
Yeah. It is.
Thanks so much. I think even personally, I now have an understanding of the dealings to do with an off-plan property, how to go about it. Well, it's been an insightful discussion, but generally, I'm pretty sure our audience would want to know if I want to reach out to either of our panelists, where should I go? Whom should I talk to? You know?
Okay. So you're asking for the insights. Where can we get more information? Yeah, so we have an amazing team of lawyers. We have team advocates who are able to guide you through the whole process or even any transaction. And when it comes to insights, we even have publications. CM Property Digest itself is a magazine, and we do publications all the time about off-plan properties, anything to do with real estate. You'll be able to find it here, and especially the trending topics. We do in-depth insight based on legal principles and the statute that exists.
Great. For Buyer in Kenya, we are a marketplace for properties. So even before you find the off-plan property, we help you essentially identify that property. We also offer other services such as connections to ancillary partners such as insurance, mortgages, everything you need in the ecosystem of sales, and also legal. I believe both of you are listed on our website, and just ensuring that you're able to be equipped to buy that property in a very informed way. Especially when it comes to off-plan, we're able to even go a step further by doing comparative market analysis reports, feasibility studies of your investment at a very affordable rate, because we've collected this data over a decade in regards to the market. So we are really equipped to help you as a buyer, as a developer, and as an agent in terms of your property, off-plan property sales. So buyerinkenya.com, that's where you can reach us. Yeah.
Thank you so much. Nonetheless, you might also want to not directly purchase an off-plan property. You might want to do this through a company. We at Net Sharia will be able to assist you also with regards to the general aspects of trying to understand how to go about your start as a purchaser. Because essentially, when you're undertaking a development investment, you're ideally a startup. So how do you go about the journey? How do you know which particular company to register? What are the intricacies involved, whether you're a sole proprietor, whether you're a private company? Do you do this as a partnership? We'll take you through the journey. We'll liaise with Vibrant Kenya. We'll liaise with CM advocates. We'll try to give you all the cycles involved in your development towards buying particular properties, whether it's off plan, whether it's advice to do with charges, whether it's advice to do with your company, and how to go about running it. Essentially, it's been a great discussion, and we look forward to the next one. Thank you.
Thank you. Great, guys. That was nice.